Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. And welcome back. Today we are in Calloway County with workers' compensation attorney Jeff Roberts. Jeff, good to see you again, guy.
Good to see you, Jim.
Absolutely. So, you've talked over the years a lot about workers' comp, obviously. The thing that I really would like you to stress today is some of the steps that people need to take in being proactive as it relates to their workers' compensation claim. Because a lot of times we tend to think, well, my attorney's working on this and I'm kind of on autopilot, but there are a few things that you really have to be on top of if you've suffered a workplace injury.
True. We've kind of talked about some of these in different episodes, but the first thing whenever you suffer an injury, the first thing you need to do is to report it to someone above you in the chain of command, to your supervisor, to HR, someone above you in the chain of command. So if you tell your coworker that works on the same line, that's not giving notice of the injury. You've got to give notice of the injury to your employer as soon as practicable after the work injury. And there's some leeway there at times. If you think you've just got a little strain and then you find out it's more severe, the judge may excuse a little bit of a delay. The judge may not excuse that delay. You don't know until the judge makes that decision. From there, the best thing to do is when you have an injury, report it to your supervisor that you've had an injury, and that will that's the very first thing you need to do, because failure to give due and timely notice is fatal to your workers' compensation claim. If you don't give due and timely notice, you do not get any workers' compensation benefits. So make sure you give that notice to the employer as soon as practical. And if it's been 3 weeks since the injury occurred and you're listening to this and you haven't given your employer notice, give the employer notice now. So make sure you give that notice as soon as you can from that standpoint.
And that just kind of gets the ball started, but at least you've gone to first base at this time.
Correct. You've gone to first base.
Yeah.
And sometimes and where I see that a lot is where the person doesn't seek medical treatment initially. They're at work and they're lift something and they have a pop in their back and a little bit of pain, but they think, okay, it's just a strained muscle, it'll go away. And they keep working, and then a month later they figure out, okay, it hadn't gone away, I need to go to the doctor. Then they go to their supervisor and say, I lifted this box a few weeks ago and had pain, and I've had pain ever since, and now I need to go to the doctor. And they're going to say, you didn't tell us anything about that a few weeks ago. Well, what day did it occur? And you probably don't know, well, it's about a month ago. I don't remember.
Just something I do every day.
Yeah, I don't remember exactly what day and things of that nature. And it just creates complications that you don't need to have from there. So when, if you lift something heavy, you have pain from it, feel a pop, have some pain from it, tell the supervisor right then, say, I lifted this box, I heard a pop, I have some pain in my back. I think it's just a strained muscle. I think it's going to go away. I don't want to go see a doctor, but I just want to let you know about it. Yeah. And so you've told them about it at that point in time. If you can put it in writing to them, that's even better. It's not required that it be in writing, but having written documentation is you don't have to worry about the supervisor going back and say, I don't remember you telling me that. So if you've got some kind of written protocol with your employer where you can do it, or if you got the email for your supervisor, shoot them a quick email. And
even a text, I would think.
A text would work too.
Yeah.
Just saying, kind of confirming this. I don't want to go see a doctor now, but just in case I have to, I want it documented about this event.
Well, I think if it's a month down the road and you start connecting the dots that, hey, you know what, this happened at work, that gives the workers' compensation adjuster or insurance company a way to say, you know what, this could have happened in your backyard or something. I mean, it may not have been caused by something at the job, so we're kind of off the hook. That's going to be one of the arguments they make anyway.
That's one of the arguments they will make. They will also send you to a doctor that is going to say if this had happened then, if it happened a month prior to this, he would have sought medical treatment. This is an injury that you start having pain very shortly after. You need to go see a doctor for it, like if you have a herniated disc or something like that. Frequently, people wait a while before they go, but there are insurance company doctors out there who will say, this would have occurred later because he would have gone and sought medical treatment, or he or she would have sought medical treatment much sooner. If it had happened a month prior, they would have been to a doctor much sooner than what they did, and basically tried to essentially call you a liar without calling you a liar.
Yeah.
And that's what the insurance company is going to do. That the adjuster is going to do that. They're going to hire a doctor, company doctor, that's going to say follow the company line, so to speak. From that standpoint, and those are things that you have to overcome that can be very difficult to overcome, frankly. And so it's much easier tell your supervisor, document that with them, or if they say, you tell them and they say, okay, we need to fill out a incident report. You fill the incident report out, you got it in writing, you're good to go, or send a text to them later on saying, just kind of confirming, I told you about this. I don't need to see a doctor now. I just want it documented in case I do, type situation. So you've got it documented from that standpoint. And what I've seen at times, it kind of depends on most employers. If you do that and you don't go to the doctor right away, but you document it with them, even with a written report, then you don't have a problem later on with the insurance company, because they go back to the initial incident report that says he had this injury, but he thinks he's going to see how things go before he seeks medical treatment for it. And the insurance company doesn't cause a big fit over that whatsoever. From that perspective, but when you start seeking medical treatment, that's when you need to go back and say, okay, this is still going on. I'm going to go see my family doctor now and see what's going on, see if there's something we can do to cause this pain to go away.
Well, you've used two phrases just recently that I want to come back to real quickly. You just said, you're going to go see your family doctor, and you mentioned a phrase called the company doctor, which we've talked about in the past.
Right.
There's an important reason that you probably want to begin with your own family doctor or your primary care physician if you have one, right?
Yes. The reason for that, a couple of different reasons. One is who they are trying to please. Your family doctor, primary care doctor, is going to be looking out for you. They're concerned about you. They want to get you the best treatment possible. If you need to be off work, they're going to take you off work. If you need to be referred to a specialist, they're going to refer you to a specialist. And without any problems. They're not going to go to the insurance company and get input from them. If you need to be off work, they'll take you off work. With a company doctor, they're not trying to provide bad care. Don't get me wrong. I don't think they are trying to provide bad care, but I think their focus is more on saving the insurance company money. So they may be a little slower on ordering an MRI to see if you've got a herniated disc in your back. They may be a little slower in sending you to physical therapy. They may be less likely, they probably will be less likely to take you completely off work versus letting you go back to some sort of a light duty and letting the employer dictate what kind of light duty that they can accommodate. And amazingly, you're allowed to go to that type of light duty position from that standpoint. So it's who they are focusing on pleasing to some extent, in my opinion, from that standpoint. So that's the reason. And in Kentucky, one of the benefits of Kentucky workers' comp law versus some other states that I'm not licensed in other states, but I talk to attorneys there frequently to discuss when person's claim could be filed in Kentucky or in another state about which state laws are going to be beneficial. One thing that's very good about Kentucky law is that the injured worker gets to select their medical provider. The insurance company, the employer, can't say, you've got to go to this doctor or we're not going to pay for it. So you can go to your own doctor and that will be taken care of. Now, there is a caveat to that, and that is if they have a managed care network or workers' comp managed care network, then yes, you have to stay within that managed care network. You still get to select the provider within that network, and they have to have a choice of providers. So they have to have a choice of family or general practitioners, family doctors in your location or within reasonable distance of your location, a choice of neurosurgeons, orthopedic surgeons, neurologists, etc. They can't just say, well, this is the only doctor we have within the network, so that's who you got to go see. That managed care network would not be approved in all likelihood. And if that's the case, you can say, look, I get a choice, and so you're going to have to give me somebody else besides this one for me to choose who I want to go to. And then the Kentucky also has a designated physician plan, which means the insurance company can have you designate a doctor to be your designated physician for this to manage your care. That designated physician can refer you to as many different doctors as they want. And that's fine, but you can only change the designated doctor one time without insurance company approval. Well, you know your family doctor, you know you like your family doctor, otherwise they wouldn't still be your family doctor. So you go to your family doctor and then the family and keep them as your designated, and they can refer you to a neurosurgeon. If you don't like that neurosurgeon, go back to the family doctor. I don't like that, refer me to a different neurosurgeon. They can refer you to a different neurosurgeon. And there's no problem. You've not changed your designated. Whereas frequently what I'll see the insurance companies do is when the family doctor refers to a specialist and they want the patient to switch to that specialist as their designated doctor, and then that takes away their one change, and then they're stuck. Yep. Because if you don't like this specialist, and you can't go to that specialist, well, I don't really care for your treatment, so I want you to refer me to a different specialist. You know what the answer is going to be in that situation. And so that's the reason I always tell people, use your own family doctor as your designated physician.
And we actually went in depth on that back in episode 68, where we talked about the workers' comp designated physicians form 113, which is actually the file, the form that'll get filed. And I think we actually put a link to that file or that form in the episode there. Jeff, so again, when we say the company doctor, we're not talking about the nurse's station, or maybe you've got a medical station there at the plant, or wherever. This is just a physician or a group of physicians that may have a so-called informal relationship with the company, and they kind of protect each other. I'll send you plenty of patients, and you make sure that the diagnosis is helpful to us informally.
True. That's what when I refer to company doctor, it's not the plant medical that I'm referring to from that standpoint. And there are some, there was one plant locally that had a family doctor that they used as their company doctor. That's who did their physicals. That's who they sent initially to their injured workers. I knew that family doctor. In fact, he had been my family doctor at one time, and he was more concerned about the patient than he was the company, and he would refer people out. And about 5 years of him being the company doctor, all of a sudden they had a new company doctor. And so that is, but when I say that, some company doctors are fine. They're more concerned about the patient. Some are not. And so, but still, you're better off. Your family doctor knows you. The family doctor knows what medications you're allergic to, what your other health issues are, and that, this medication, you may be a diabetic, and so there's certain medications you don't need to take because it will affect your diabetes from that standpoint. And hopefully, if you go to a company doctor, they will get all that history and take that into account. But your family doctor already knows that's going to document that and take care of that right off the bat. And also, they can say, yeah, I've treated this guy for years, and he never had these symptoms beforehand. So this is something new. So.
Well, yeah, and that comes back to pre-existing conditions, that Correct. Now have been aggravated by the workplace injury. Correct. And so, again, that's something else that having somebody who's treated you for a while or at least is familiar with you, that can actually,
Right.
play to your benefit a little bit.
Yeah.
Jeff, another factor that an injured person, or let's just say somebody that's had a workplace injury, needs to do in terms of being proactive with their workers' compensation case is they need to communicate with their attorney. And that's something that I would think from your standpoint ought to be a little frustrating when that doesn't happen. But I know you. I know you're a very proactive communicator, but that goes both ways, right?
It does. During the initial meeting with the client, when I sign them up as a client, one of the things I tell them is keep me informed of all your doctor's visits. When you go to the doctor, call us up after the visit. Let us know what the doctor said. Let us know when the next doctor is. If he's referred you to an MRI, let us know when that's scheduled. Physical therapy, let us know when that's scheduled and where you're getting that done at, and all of those things. And most clients are pretty good at that. Especially initially. Then after a while, they kind of sometimes forget to call in. But one of the reasons we do that is we document that. So if they call up and say, "Well, I saw Dr. XYZ today for a visit. He's ordered 6 weeks of physical therapy, and then I go back to see him on December 13th." We put that in our computer system. December 14th, 15th, we haven't heard from the client. Then we call the client, so you went in, you were supposed to see Dr. XYZ on the 13th. Did you see them? And then what did they say? And then we get that information from the client ourselves. So having that, we get to keep on top of the medical treatment, on top of what's going on with my clients. Because if I know going in what's taking place, it can help me to prevent problems from occurring, help get a treatment approved quicker, things of that nature. So,
well, Jeff, and there's also another factor in communication that, again, proactively, if you've been injured on the job, you also need to keep your employer up to date on your medical status, right?
Correct, at least on your work status.
Mm-hmm.
I don't think it's as important to let the doctor or the employer know I'm seeing this doctor on this date, but if you're off work, you need to let the employer know, give them the off work slip. So if you see the doctor on September 13th and they keep you off work until October 20th, and so you let your employer know that, and then you see the doctor again on October 19th, and they keep you off work until December 1st. Well, if you don't tell your employer that, they're expecting you to come back to work on October 21st, and then you don't show up for work and you're a no-call, no-show type situation there. So you need to let the employer know of your work status, give them off work slips, make an extra copy and give me a copy of your off work slip and keep a copy for yourself. If the doctor puts you on restrictions, you need to tell your employer that, because if they can accommodate those restrictions, that workers' comp check is going to stop and you need to go back to work. So you need to let them know that. Keep that the restrictions with you. Give a copy to the employer. Give a copy to me as well. Because amazingly, doctors when I order records, they don't have off work slips and they don't have the restriction slips in the records they provide me.
Strange how that happens.
Yeah. Well, I don't even know that they keep a copy of it, to be honest with you. Now, a lot of times, the office note will say off work or return to light duty or something of that nature, but the slip itself is not part of it. It's something they handwrite and give to the patient, and the patient leaves, and they don't even make a copy of it, I think, is part of what goes on. But that's where, part of keeping me informed is doing that, part of keeping the employer informed, so that you don't have problems with the employer saying, we thought you were going to be back to work and now you're not back to work. What's going on? Because that can cause some, frankly, if you're a no-call, no-show, if you're a union shop, that would do it. But if you're not a union shop, that's grounds for termination in Kentucky, and they very well may not be able to do anything about that in that situation. So,
wow. I mean, so that's a big deal. I mean, you really,
yes.
I know a lot of times, anytime we're doing a podcast episode, we talk about as the attorney, you do a really good job of shepherding the case. You take a lot of the stress and strain off of the client, that you're representing. But there is a need to be proactive. I mean, you don't want to just lay back and assume, well, everybody else is handling it, I'm good to go. There are some very specific steps that you need to be aware of.
Correct. And if, when there's an insurance company involved, I don't reach out to the employer and talk to the employer. I don't know ethically if there's an attorney involved, I can't talk to the client. I think that applies the same with an insurance company. I'm not supposed to talk to the insurance company's client from that, so I don't do
Which would
that.
be the employer.
Which would be the employer, so I don't do that from that perspective. So it is, I can fax something to them. So, if you bring in the off work slip and say, could you fax this into my employer for me? We're going to do that from that perspective. But to call up the employer and say, just let you know, my client saw the doctor today and they're going to be off work for another 6 weeks or whatever. First off, they're probably going to say, we need that from them, not from you.
Right.
But even then, I don't think, once they've told me about their insurance company, I don't think I'm allowed to do that, or at least I'm not going to run that ethical risk and risk my law license over that. So I tell my clients, in the initial letter, the client has it in there to keep the employer notified of your work status from that standpoint.
Because as the attorney, you're going to speak to the adjuster for the insurance company, or you're going to, if it's an actual case here that's been filed, you're going to be speaking to the other attorney, not the employer, correct?
Correct.
I mean, that's kind of the way it goes.
Exactly. And just like once I get involved, the insurance company should not be talking to my client. They should be going through me.
Yeah.
Sometimes they have a rehab nurse that goes to doctor's appointments and all, and I, depending on who it is, I may agree, may not agree if they agree to my conditions from that. But if I agree, then it's okay for that rehab nurse to talk to my client. If I don't agree, then they can't talk to my client either. So,
Well, Jeff, let me take you down another rabbit hole here, if you don't mind. This is, a lot of times if you've been injured and suddenly you're starting to get some checks, okay, they're paying me my TTD payments, right?
Correct.
They're paying me my temporary disability.
temporary total disability.
Yep. That doesn't necessarily mean a claim has been filed. And there's another issue here dealing with the statute of limitation that can come into play that, again, you need to be careful with. It's another reason to have an attorney on your side. But you've got to be careful because a lot of people think, well, the company's taking care of it. Again, they're letting somebody else take care of it because they're getting a check, but it's not actually a workers' comp necessarily, right?
Well, that can be.
It's related, but it's different.
It depends. Where I see that come in a lot is where the employer will say initially to someone, well, we're not going to turn this in on workers' comp. I'll pay the medical bills, I'll pay the emergency room bill, and I'll pay your salary until you get back to work. And so you're getting paid your full salary or whatever. The employer is paying you, not the insurance company. I see that occur a couple of different times. One, when they think it's just going to be a few medical bills, they'll send you to an occupational medicine place, and then and medical bills aren't going to be very high. You're going to be off work for about a week and be back to work, and they're afraid that their insurance rates are going to go up if they have another lost time accident, so they don't want to turn it into their insurance.
It's the same as if you're in a car wreck. Sometimes you want to fix it yourself and not turn it into the insurance claim. They're doing the same thing.
Correct. From that standpoint, the same thing. And I see it in that situation. I see it when the employer doesn't have workers' comp coverage. That's a completely different situation that we can deal with. But on the first one, what happens is then whenever they see down the road, okay, this is more than what we thought it was going to be, and we're 6 weeks, 3 months down the road, and they say, okay, this person's not getting better. Now the doctor's talking about surgery. I'm not going to pay that. I'm going to turn it into my insurance company now. And if you got good documentation, written documentation that you've told them about the injury, you're fine. The employer's job to notify their insurance company. They can't hold that against you. They can be irritated and find their employer maybe, but they can't do anything against the injured worker. The risk that I see coming in on these is at times you will have the employer say, well, he never told me this was work-related until 3 months down the road, even though you told them right off the bat. That's one of the other reasons why you document it in writing. You send an email to them, do something, document it in writing. This is work-related. You've said you don't want to turn this in, so I'm submitting the bills into you. You're going to pay me my full salary. But what you were getting back to your point is if the employer pays you your full salary, that is not temporary total disability. It does not extend the statute of limitations for your claim. You've got a 2-year statute of limitations that's from the date of injury or the last payment of temporary total disability. Payment of medical bills doesn't extend it. The employer paying you your full salary does not extend the statute of limitations for you. So you've got to keep that statute of limitations in mind from that perspective.
And what happens in practical reality? What happens if you don't get the claim filed in time and the statute expires?
You've lost your claim. And then the employer is not liable for anything in the future. They're not liable for future medical bills. They're not liable for your permanent disability. They're not liable for any temporary total disability that may come up in the future. That you've basically given up your claim. You didn't file it in a timely fashion. You've given up your claim from that perspective. So.
And all along you thought you were being taken care of, and actually they were running out the clock on you.
Correct.
You know, which is, again, some of the games that people play here. But it's a reason to not only have your attorney involved, but proactively communicate with your attorney and to make sure that this thing is going on. You don't want to let your claim just sit out there, because if you're trying to do it on your own or you're being kind of lackadaisical, bad things are going to happen. You've got to maintain a little bit of control in this. And a good attorney is going to help you with that. As you said, you'll put dates on the calendar and you'll follow up with your client. But some offices do it differently, and they may put a little bit more of that responsibility on the shoulders of the client.
Correct. I think once you have an attorney, I think it's the attorney's obligation
Yeah.
at that point to make sure the claim's filed within the statute of limitations. And if they don't, then you've got a legal malpractice claim against the attorney from that perspective. But what I've seen is insurance companies will pay the medical treatment and tell the person, we're going to take care of this. We're taking care of your injury. Don't worry. We're going to take care of your medical bills. Go see the doctor. We're going to take care of it. Person's back to work or never did miss work, but they had ongoing problems. Yes, we're going to take care of everything for you. And then a month after the statute of limitations expires, we don't have to pay for any medical in the future. You told me you were going to take care of it, so you let the statute of limitations expire. Now we're not legally obligated to take care of it anymore, and that is that can be devastating for folks. I had luckily I was able to get a way around the statute of limitations. There can be ways to get around the statute. So if they're telling you the statute's expired, talk to an attorney, because there may be a way around that, because there's certain things the insurance company has to do as well. And if they don't do that, but it was a person I represented, and they had this work injury, off work for a period of time, went back to work, kept having problems, and had to have surgery, off work again, went back to work, worked for a long period of time, going to have another surgery, and this was probably a year after statute of limitations has expired, and when they went back to the doctor, and the doctor said, you're going to have another surgery, and the insurance company said statute of limitations expired. Luckily, in that case, the insurance company hadn't done what it was supposed to do, so I was able to get around the statute of limitations for that gentleman. But that was, if not, that was a career-ending injury for that person, and they would have been out of luck, unfortunately, because there wouldn't have been anything else if it wasn't for that little that he fit in that one little section that allowed us to get around the statute, but otherwise it could have been devastating for him.
Well, Jeff, let's finish up the episode with this one thing. And you mentioned something earlier in the episode that may have thrown up some red flags for people, but we're hopefully going to put a bow on this topic for you. The fact that one of the reasons that the employer may say, "Hey, we're gonna handle some of this for you," maybe because they don't have insurance, they don't have workers' comp insurance in active status. You want to talk a little bit about that, because there is a happy ending here for the injured worker.
It certainly can be a happy ending in that situation if the employer does not have workers' compensation coverage. In Kentucky has what's called the Uninsured Employers Fund. It's a fund that is funded actually by workers' comp premiums. Every part of every premium dollar goes into the workers' comp Uninsured Employers Fund. And that is that's to take care of claims from employers who do not have workers' comp coverage. So Now, what that means is, unfortunately, what it means is if they don't have workers' comp coverage, you're going to have to litigate that case. They're not going to voluntarily pay anything. You've got to have a judge's decision to get the uninsured employers fund to pay. But ultimately, we can get the uninsured employers fund to pay the workers' compensation claim the same as the same amount as the insurance company would have paid. From that perspective, it's just not while you're ongoing with medical treatment and all of that. We've got to litigate to get a judge's order. Sometimes you can do that quicker. Sometimes it takes a little longer to do that, depending on the case. But there is at least an avenue for recovery there. Another side, the one thing that a lot of people don't think about, a lot of attorneys don't think about this, is if the employer is uninsured, then they have waived the exclusive remedy provision of the Workers' Compensation Act. And basically what that is when you're injured on the job in Kentucky and every other state that I know of, your only claim against the employer, no matter how negligent or grossly negligent the employer was, your only claim is workers' compensation if they have insurance coverage. In Kentucky, anyway. There's two ways around the exclusive remedy in Kentucky. One is if the employer intentionally injures the employee, which I've never seen applied in my career anyway. The other is if the employer does not have comp coverage. If they don't have the coverage, then they've waived the exclusive remedy provision of that. And I've had cases where I was able to, the employer, you got to establish negligence. In those cases, you can get workers' comp benefits and sue them civilly. And I've done that a few different times in my career and gotten some very good recoveries for my client in those situations where we've been able to get around workers' comp, and we've able to get the workers' comp claim plus a civil judgment that was worth a lot more than the workers' comp claim. So.
Wow. Friends, if you want a little bit more information about that, check out episode 33. And again, as I've done in the past, I'll put a link in the show notes so that you can link right to that. But you can also find it at jeffrobertslaw.com. If you go to the podcast section and scroll down to episode 33, we talk about what happens if my employer doesn't have workers' comp insurance, and a number of these factors have been covered in that episode. So, Jeff, I really appreciate your help here. Now, if somebody's listening to this and they realize, you know what, I just need to hire a good attorney, and they want to get on the phone with you and talk to you about their case, you've got two offices. You've got the primary office here in Murray, Calloway County, but you've also got the one in Hopkinsville up in Christian County. But luckily for them, there's one phone number to call, right?
Correct. I have one number. It's 270-753-0053. That's the number to call my office. There is an 800 number. If you want to use 800 number, it's 1-800-844-5108. And so you can call the office. And we will see what we can do for you from that standpoint.
And that's a free consultation, right?
The initial consultations are free from that standpoint. And when you call in, my office motto is to provide small town service and deliver big city results. Part of providing small town service, in my opinion, is having a live person answer the phone instead of having to listen to a computer or some answering service in somewhere in some other community or even some other country that's not affiliated with my office. When you call my office, you get a live person who works here in my office that's going to be talking with you, getting some information. If I'm available, letting me know about the call. If I'm not available, getting information for me to look at so that we can look at getting an appointment scheduled for you.
Outstanding. Jeff, I really want to thank you for your time. I know you're busy. We've talked a little bit about your case schedule and things like that, and you're taking cases from all over the place here in Kentucky because, again, you've got 33 years of experience. You're handling two separate offices, and you're also getting a lot of referrals from your not only your clients but also from your colleagues, which is another testament. Friends, I would encourage you very, very quickly to take a look at Jeff's Google reviews out there on his Murray, Calloway County Google business profile. He's got, as a solo attorney, he's got so many 5-star reviews, and I think that really backs up that motto that Jeff mentioned earlier, and also the kind of respect that Jeff's earned from his colleagues, and that's one of the reasons they refer their cases to him, especially in the area of workers' compensation. So, Jeff, once again, thanks for your time, guy.
Thank you.
Bye-bye. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.